All right, folks, it's time for our favorite, yes, our favorite podcast, Cut to the Chase. And I'm bringing Amanda Bronstad back from ALMlaw.com, legal journalist extraordinaire, because there's breaking news on the Roundup litigation, and I can't make heads or tails. And so instead of being a good lawyer and reading all these decisions, I figured I'd just bring Amanda on here and have her tell me what is going on. So how are you doing today, Amanda?
I'm okay.
Okay. Okay is better than bad, I guess. So we'll go with that. We both are in a different background. I believe you're, West Coast, and now I'm up north. So a little different look than our last podcast. Some of you might be like, whoa, what's going on? But that's what's going on. All right, cut to the chase. Let's go. SCOTUS, Roundup, news yesterday, what happened? And let's discuss everything you know about all the other things going on with Roundup in the world of litigation.
Okay, so yesterday, the United States Supreme Court declined to review a petition that Bayer had filed that it was depending on in large part to try to reverse some of the, well, in this case, the Ninth Circuit's decision on federal preemption in the Roundup litigation. The reason this is important is because last year, Bayer announced a 5-point plan to try to resolve the Roundup litigation. This was a really key point of that. And that was to try to get its arguments in front of the Supreme Court. Now that the Supreme Court is not going to review the case, it's a big setback for Bayer. So that kind of makes them fall back to some of the other options that they have on the table. And they definitely have a lot of other options out there. But I do think it speaks a lot to, this was probably their most important element of trying to get Roundup resolved. And the fact that the Supreme Court's not taking it up is a really big deal.
All right, so talk generally speaking about federal preemption and what the actual issue was that they were presenting that they wanted the Supreme Court to address.
So the main issue here is that they're very concerned about the label on Roundup, and that is saying basically that it might cause cancer. And one of the arguments is that glyphosate, the key ingredient in Roundup, is a carcinogen. There are a number of scientific findings that say that. The EPA, however, does not say that. And so what the argument that they were trying to say in front of the Supreme Court was that federal law preempted any kind of claim that Bayer had failed to warn about the safety risks of using Roundup. That's been the key argument in all of the trials as well. So if they could have gotten the Supreme Court to take up this case and rule that yes, indeed, federal law did preempt these claims, it would wipe out pretty much the main argument in the Roundup litigation. So that was why it was such a big deal. The fact that they are not, however, going to back down from this argument. So they can continue to do this. The Ninth Circuit did come out with the ruling, however, just yesterday that basically said that EPA needed to relook its glyphosate decision. So I do think that that Bayer's got a lot of challenges up ahead in terms of making this argument in other courts, which it does plan to do.
All right, so just on the specifics of the case that SCOTUS refused to address. The plaintiff's name in that case is Hardiman?
Yes, I'm sorry. This was actually one of the 3 trials that Bayer went to in California. This was the second one. It was in federal court. It was actually the only trial in the multi-district litigation. And the plaintiff was named Edwin Hardiman. It was an $80 million verdict in 2019. And it went before the Ninth Circuit, which upheld the verdict, which got lowered at some point. And then that's how it ended up in front of the Supreme Court. There were 3 verdicts over the last 2018 and 2019 period, totaling about $2.4 billion. And so this was not the major one, but it was one of the big verdicts that was causing an issue for Bayer. So one of the things that's interesting about their statement yesterday was they did point out that they have a second petition in front of the Supreme Court that they filed on March 17th. And that is in a 3rd trial that involved a $2 billion verdict. Again, that got lowered. That was for a couple named Alberta and Alva Piliad. And that was in 2019 as well. It was actually in state court, but it's been moved up to Supreme Court to get to hear the exact same issue. So it's pretty much, there's some factual distinctions, but it's the same argument that they tried to make in the Hardiman case.
All right, and this is the issue that the Biden administration was requested to take a position and they refused to do so, or they reversed the position that the prior administration had taken?
Well, that was actually something that came up in the petition that just was not taken up yesterday. And that was the Solicitor General filing an amicus brief saying that basically the Supreme Court should not hear the case. And that was such a big deal because the Justice Department did side with Bayer on federal preemption back when the case was in front of the Ninth Circuit. I think there's some idea that perhaps the switch in administrations and the switch in position in this case may have been possibly one of the reasons the Supreme Court did not take the case.
All right, so now apparently from what I'm seeing, next week, the Supreme Court is going to talk again about whether they want to take the second case, which essentially deals with the same legal issue.
Yeah, that's the speculation. I think it's going to go in discussion this week. And then there's a possibility, given the term that the Supreme Court's at, like the stage of it right now, that they may rule on that next week, or at least decide whether they're going to actually take up the case.
All right, so they have to decide whether they take up the case before, and then it gets briefed and everybody does oral arguments, and then they make the rule. Then the initial opinion gets released, and then there's a big scandal, and then
Yeah, right.
No, I'm kidding. No, that's not the way it works. Okay.
And we should be clear, there's no ruling from the Supreme Court. There's no ruling. What this was they just decided not to even hear the case.
Yeah, they only take a small percentage of the cases that are brought to them. And so it's not, out of the ordinary that they would not hear the case. That's normally what they do, unless there's a split amongst the circuits, and there's no split on this particular question.
I don't really know the reason they didn't take it up, but you're correct. It's pretty uncommon to get taken up in the first place.
All right, so you referenced a Ninth Circuit opinion on the EPA's decision saying that glyphosate does not cause cancer. And the EPA, and the Ninth Circuit said the EPA messed up and needs to reconsider their position or the way they were looking at it.
Yes, I think it was more what you just said in the latter part of your statement there, that they need to reconsider their position on this. I think there's a lot of scientific findings on both sides, and that's part of the problem with this issue. And the fact that Bayer's hanging its hat on the EPA's position on this is definitely a big deal on what the Ninth Circuit said yesterday, because now another court is saying that the EPA needs to look at its position on whether this is a safe chemical. I think that one of the 5-point plan options that Bayer has in front of it is to reformulate Roundup so that glyphosate is not a major ingredient or not an ingredient in the product. And I do think that's something that they are definitely considering. They definitely want it to be done in a limited amount and in their own scientific, they're very much, the science is on their side. So they definitely want to be having that discussion, but I think that's something that they want to play an active role in.
All right, so a lot of times these cases, these mass tort cases come out because a product is recalled, or there's a voluntary recall, or they take it off the shelf. This case, they have not taken it off the shelf, and you're talking about a 5-point plan. Can you give us the summary on what that 5-point plan is?
Right, yes, I can. So one of them is the Supreme Court petitions, and in addition to the second one that we're all waiting to see whether the Supreme Court takes up, there's also an appeal in front of the 11th Circuit that they are bringing. In that case, the district judge actually ruled in their favor. So that's when they're trying to affirm in front of the 11th Circuit. But if they can create a circuit split with the 9th Circuit saying one thing and the 11th saying another, it could potentially have a third case in front of the Supreme Court. So the appeals are one element of the 5-point plan. A second one is the reformulation of Roundup. A third one is a new label. All of these things are things that, again, Bayer wants to have an active role in. A fourth one is just settling some of the remaining cases out there. They have agreed to pay $10 billion to roughly to settle about 100,000 cases out there, but there's still 30,000 more. So that's an option. It doesn't sound like it's something they're in active discussions about right now. The fifth one that I think is that came up yesterday in their statement was the claims process. And this goes to what you were just saying. Roundup is still on store shelves. So even if they settled all 30,000 cases, they still have future cases that could be filed and going forward because people are still buying the product. So they have a problem on how to resolve those future claims, they call it. The claims process is how they're going to do that. They did mention the claims process yesterday. A year ago, they set aside $4.5 billion for this claims process. So it is something in the works. They do say they're committed to it. However, they also said that they were committed to it, but they were also looking at how they were doing in court. They've had a number of trials, in particular 4 verdicts on their side in the last year. It's a big shift from what was happening when they first brought this Supreme Court petition in front of the, Supreme Court. So instead of $2.4 billion in verdicts that they lost in 3 verdicts in a row, they now have 4 verdicts in their favor in a row, and they've got more trials coming up. So I do think they see that as a pretty big shift in court. And, you know, I don't know if they're so ready to resolve everything when they're doing very well in front of jurors.
Yeah. All right. Well, we're going to end it on that note. And I thank you, Amanda, for coming on short notice, but it was big breaking news. I think, you know, there's so much going on, like, you know, we're all trying to make heads or tails in the quickest way. And so you have done us a great service, clearing up a lot of these points. So again, thanks for coming on short notice.
No problem. And it's a really complicated issue. There's a lot of moving parts in this litigation, so I can understand the the confusion.
Yeah, no, I mean, we didn't touch everything. The International Agency for Research in Cancer, they had their probable carcinogen, that the glyphosate is a probable carcinogen. That evidence had been admitted in trial, and I think Monsanto Bayer was trying to, you know, get it reversed, saying that, you know, that evidence shouldn't have been brought in. And then you have the EPA on the other side saying it's not a cancer, and now they're getting questioned about that by the Ninth Circuit. So it's moving parts. Anyway, everybody take care. Amanda's going to come back when we have more confusion in the world of mass torts and class actions, which I have a feeling is not going to be that long in the making.
Thank you very much.
All right, everybody, subscribe, rate, review, questions, comments. If you have any questions you want me to ask Amanda in the future, please let me know. And that'll do it for this episode of Cut to the Chase. Thank you.
Okay, thank you.